Medicaid planning, it's not simply about preserving the most assets or qualifying for the most benefits. It's really about the client's goals and priorities.
Hello, and welcome back to the Financial Advisor Technician Podcast. I'm your host, Adam Van Dusen. On today's episode, we're going to discuss Medicaid planning in the context of long-term care, a topic that often comes up for financial advisors working with older clients who might be preparing for a potential need for long-term care, but can also arise when working with younger clients who are supporting an aging parent through the long-term care process. While there are several planning strategies that can help individuals requiring long-term care to avoid drawing down their assets in order to qualify for Medicaid, these strategies come with trade-offs that might be acceptable to some clients while perhaps not being a preferred option for others. In addition, an advisor might find themselves in the situation of dealing with competing interests among family members, such as an older client who might want to preserve flexibility in their long-term care options, or adult children who might prioritize preserving assets. To help us dig deeper into this topic, I'm joined today by David Haughton, the Vice President of Estate Planning at Carson Group, to discuss the different types of Medicaid planning strategies and their trade-offs, ethical considerations for financial advisors when working with clients on this topic, and how advisors can take action with their clients today to create the best possible outcomes down the line. So welcome, David, and thanks for joining the Financial Advisor Technician Podcast.
Thank you so much for having me. I'm so excited to talk about this important topic.
Terrific. So to start, perhaps you could provide a quick introduction on what Medicaid planning is in the long-term care context and the different types of clients for whom it might be applicable.
Absolutely. So, at its core, Medicaid planning is really designed to help someone qualify for long-term care benefits under the state Medicaid program and be able to preserve as much of their assets as legally possible. And that's usually for the benefit of their family that comes after them. So if someone is in need of nursing home or other long-term care, typically what happens is they need to spend down their assets if they have too many what's called countable assets to be able to qualify for Medicaid long-term care benefits. And so absent doing any planning, that means that clients would typically need to spend down a substantial part of their assets on care before they start seeing any benefits paying for their care. So what Medicaid planning really is looking at the law and looking at the guidelines and seeing what assets can be legally transferred. Can you convert them, the character of the assets, reposition them in certain ways so that they're no longer counted against the Medicaid applicant's eligibility and therefore able to have the Medicaid program pay for their care. And when you're looking at who are the applicable clients for these types of programs or for this types of planning, it's really people who, obviously it's in the aging population, people who are concerned that they're going to go into long-term care. They're concerned about the dissipation of their assets and how much they're going to be able to transfer to their family to preserve that wealth, where they would rather have that wealth transferred to the family rather than spend those assets on long-term care benefits personally. So at its very core, that's kind of how long-term care Medicaid planning works.
Yeah, thanks for that rundown. I do think it's interesting because I think a lot of folks, and especially a lot of clients, I would guess, think about Medicaid in the context of health insurance, which is typically for lower income individuals. But as you're noting here, even individuals who might have, amassed some assets could potentially benefit from the Medicaid benefits when it comes to long-term care, just given how that can add up into the, tens or hundreds of thousands of dollars that could really eat up an individual's assets that they've saved.
Absolutely. Yeah. I think Medicaid planning has a lot of use going up the net worth scale. I think once you reach a certain level of net worth, and that's a sliding scale, it depends on the state and the benefits that are available and how the spend down process works. But in a lot of circumstances, it's not necessarily just those who are impoverished who are looking to do Medicaid planning. It can be those who have accumulated quite a bit of assets, because there are a lot of strategies available that are legal strategies to be able to reposition assets or to spend them down in a way that benefits the family without having them represent countable resources when they're trying to determine Medicaid eligibility. So if a client has prioritized this and they're comfortable with that type of planning and the trade-offs I'm sure we're going to talk about that come with that type of planning, it really opens up the universe of people who may be willing and prioritize this type of planning.
Yeah, that's a really good segue. Perhaps you could talk about a few of these strategies that clients could use to perhaps protect some of their assets, but still qualified for Medicaid for the long-term care benefits.
Absolutely. Yeah. And I think, the first thing I want to discuss is that because the way that Medicaid works and Medicaid planning works for long-term care benefits is that if you're going to spend down your assets, then you're essentially going to give up control of those assets in basically every circumstance. So there's always a trade-off. So any strategy that we're talking about when it comes to Medicaid planning, it doesn't mean that the person can whistle along and keep their assets and keep full control of their assets. Usually there is going to be some kind of trade-off where they're going to either gift the assets away or give up some level of control of those assets. And so just to run through, a few of the different tools are available. Number one, the most basic is outright gifting of the assets. So you could give the assets to the children potentially, and you could give those assets away and they will no longer be countable as the Medicaid applicant's assets when it comes to Medicaid planning purposes. However, there is what is called a 5-year look back period. So if you give them away the day before you apply for Medicaid benefits, well, they're going to say you can't do that. You had to have given them away more than 5 years prior to applying. And so there's a long runway there as far as deciding to do this type of planning. And of course, if you're giving the assets away, let's say you're giving away a brokerage account to the children, there are a number of different risks associated with that. What if the child has, enters into a divorce? What if they have creditors? What if they have substance abuse issues? The other thing is, what if the parent never needs long-term care benefits? Usually those assets might be entitled to what's called a step up in basis for capital gains purposes if they're to pass away with the assets in their estate, versus if they transfer them in kind to the children, there's going to be carryover basis. And if the kids liquidate those assets, there's going to be a capital gain. So when it comes to outright gifting, there's benefits to it in that you're getting the assets out of what we would call the Medicaid estate. They're no longer countable resources, but there is that drawback and all those risks associated with doing so. Now, another potential strategy that's available would be an irrevocable Medicaid trust. And that is kind of like simulating giving the assets away. And basically the way that a Medicaid trust works is you would put assets into this irrevocable trust. The trust would say that you are not the beneficiary of that trust. So if you put assets into a Medicaid trust and you expect them to be excluded as countable resources, then you cannot be the beneficiary, at least as it pertains to principal. Whether you can be a beneficiary as it pertains to income is depend on the state. Whether you can be the trustee of that trust is going to depend on the state. Everything I'm talking about is very state specific, and it's important that an attorney that is well versed in your local state is involved in this to understand these nuances. But a Medicaid asset protection trust is something that you could use where you could put the assets in. If the 5-year look back period passes, so 5 years goes by, those assets are in a trust, protected, and not countable as Medicaid resources. So that could potentially be another tool. And then the last tool I'll briefly mention is a Medicaid annuity. And so a lot of times when a Medicaid applicant, a person who is seeking long-term care, a person who is seeking to do planning for long-term care as far as Medicaid planning is concerned, if they have a spouse, that kind of opens up more planning opportunities. And one of those opportunities is that if the person who is seeking Medicaid care, if they have assets above the countable resource limit, they can sometimes purchase a Medicaid annuity so they can change the character of their assets. So let's say they had $500,000 in a brokerage account. They could transfer those assets into what we would call a Medicaid annuity, and it would change the character of those assets from a countable resource into a stream of income payable to the non-institutionalized spouse. And it's kind of a workaround where you can change the character of the property and get the assets into the spouse's name. Now, this would never be a product, I think, that anyone would use as an investment. It would be a SPIA, so a single premium immediate annuity for the shortest possible term that you could choose, because you're playing the game of, is that person going to end up needing care before the annuity gets completely paid out to the spouse? But it is kind of a workaround in the law where if someone is going into the nursing home and they have excess resources and they have a spouse, there is a quirky way in which you can change the character of those assets from a countable resource into a stream of income and really protect a significant portion of the assets.
Okay, thanks for the rundown on each of those. And, as you mentioned here, and this is going to be a core part of our conversation, is that there are a lot of trade-offs going on here in the sense that there's no sort of, free lunch, as it were. Either the individual who might be planning for long-term care is giving up control of their resources, perhaps earlier than they might have otherwise, or perhaps if they hold on to the resources, might need to spend them down. Now, of course, they'll be receiving care in compensation for that. But at the same time, it might have had other objectives for them. So I think that's a great point. Now, as we've talked about having different sort of roles and different individuals here, why don't we talk about from the advisor's perspective? I could see this kind of getting thorny depending on who they're working with. So, for example, if you're working with, let's say, an older client, you're helping them decide, well, do I want to, is my priority to be able to gift assets, or is it the flexibility to hold on to the assets and perhaps use them to choose a long-term care option that suits me rather than perhaps going on to Medicaid? But if I could see if your client was an adult child, maybe they're a power of attorney, they might have different questions. So perhaps you could talk about, the importance of that, both in practical terms, but also ethically for the advisor.
Yeah, I think it's incredibly critical that the advisor is looking at, okay, who am I talking to and who is the client? And you might think that always who I'm talking to is the client, but not necessarily, because there's nuances, especially when it comes to elder care issues, because a lot of times people are getting older and they are actually appointing a child to be their representative, usually under a power of attorney. And so the advisor really needs to ask the question when, let's say, an adult child comes in and is looking for advice for how to protect assets for their parent for Medicaid purposes, they really need to ask, who is my client here? Who do I owe a duty to? Is it the parent themselves? Are they the actual client? Is it the child who is looking for ways to protect assets that are eventually likely going to stay in the family or reach them? Or maybe the priority of the parent they have expressed is to keep assets in the family? Or is that child acting as agent for the parent under a legal document like a power of attorney? And does that child actually have a fiduciary duty to the parent to make sure that they are planning on their behalf and not on their own? So this can get messy, and this is really, really important to understand, especially when the parent maybe has diminished capacity, because then you can blur the lines as far as who is the client, who should I be acting on their behalf, and how do I guide this person in the best way possible? And so it's really important to make sure that you understand all of these different components and understand what capacity they're looking for. What is the person who is potentially going into the nursing home or already into the nursing home? What are their priorities? What duty do you owe to them versus what is the child's role in this? Are they coming to you in their own capacity? Or are they coming to you on behalf of someone else who is the client, either through a power of attorney or other means? And these are really, really, really critical things to understand to make sure that you're acting on the appropriate person's behalf and you're acting in an ethical manner.
Oh, very interesting. Yeah, because I could see advisors being in sort of either of these positions, as it were. Some might be working with, a client, maybe it's in their 50s or 60s who has an aging parent, or, having older clients themselves. So it sounds like from what you'd said before, thinking about the look back period, being 5 years, it would seem like a best practice for an advisor would be to start this planning process in advance. So, perhaps we could start with, each of these sort of client cases. Let's look at, a client who is preparing to age or might have a future long-term care need. At what point or at what age might the advisor start this conversation, and what might that look like?
I think as early as possible. There certainly can be circumstances where it is essentially too early. I think what's really important is that there are two types of Medicaid planning. There's planning for a crisis, and then there's proactive planning. And so proactive planning is what we were just talking about. That's where you may be doing planning where you're actually gifting the assets away, either into a trust or you're gifting them outright to get them out of being accountable resource for Medicaid purposes. In that circumstance, in most states, if not all states, you need to have at least that 5 years pass by. In that circumstance, you're probably not going to make that decision unless one of two circumstances is present. You have some kind of pending diagnosis or concern that long-term care needs in nursing home services are going to be necessary in the somewhat near future. If it's too near, then you may not have 5 years, but in the somewhat near future. Otherwise, you may have it top of mind. It's a very important topic, but instead of doing proactive planning where you're actually outright gifting assets out of the, let's call it the Medicaid estate, as opposed to, let's say, the federal estate tax estate, and I can talk about the difference between those. You may want to discuss it with your attorney, and you want to make sure that you have the flexibility within your documents to be able to do some of the crisis planning, spend down planning when the time comes, if it comes more urgently and you don't have time for the 5 years. And one example of that, I talked about this Medicaid annuity, this single premium immediate annuity. If the person who is entering the nursing home has a spouse, they didn't have time to do the proactive 5 year planning. They want to make sure that their power of attorney or their trust or wherever their assets are located, that they have a fiduciary available, whether it's their trustee or their power of attorney, who actually has the power to do Medicaid planning on their behalf. So they have the power to liquidate assets. They have the power to transfer assets to the spouse to open an annuity. They have the power to spend down assets on certain things that will help them to become eligible for Medicaid. That's where the Medicaid planning is an important aspect as early as you create your documents, but sometimes you want it to be in a flexible fashion and you don't want to make the huge trade-offs where you're using that 5 year rule because that means you're going to be giving up control. And if you're doing that in your 50s and there's no significant health concern, then you're going to be giving up a lot of control for a long period of time potentially, and you may never actually need to use those tools. You may actually never end up in a long-term care situation where you need Medicaid. So it's important to understand what's the urgency, what are the priorities, and what are the tools that are available.
Oh, very interesting. And I'd imagine, on the younger end, part of that conversation is sort of the broader long-term care planning conversation. So things like, maybe they're interested in a long-term care insurance policy, or are they going to self-insure? So a lot of the questions there. So, you mentioned sort of the crisis situation. So let's say, someone has a medical incident that appears that they're going to need, long-term care for a while. Maybe they fall into this zone, sort of, as you mentioned, they might not have enough assets to self-insure, but they do have assets that they want to maintain, let's say, for a spouse. So what are their options in that crisis situation?
Yeah, so in that crisis situation, the Medicaid annuity is certainly the number one probably used if they're married, where you can change the character of the assets. Other than that, a lot of times what you're looking at how can I convert countable resources into exempt resources? And some of the ways to do that is, and each state can potentially be different, but some of the ways to do that is to look into what are the available assets that Medicaid does not count as countable resources. One of them could be a vehicle. So they could spend money on a vehicle. That could be one spend down, a way to use spend down provisions. Another could be prepaying for a funeral. and doing one of those prepaid funeral contracts. That's another way to spend down assets. So each state has different aspects of what they call accountable resource and what they say are exempt resources. And in many circumstances, they're not going to count it against the 5-year look back period if you convert accountable resource into an exempt resource. You just need to be careful and understand in each state what these different categories are can vary greatly, because in some states, a retirement account, a qualified retirement account, IRA, 401k, depends on the circumstances, may have added protection versus a typical brokerage account. Whereas in other states, like in Massachusetts, they may not see a difference between the two. And so looking at those different assets and what is countable, what is not countable can be really important in how to convert between the two. The other thing that is interesting is that sometimes you kind of understand that there is going to be a period of time that we have to pay for long-term care privately. It's just there's no way around it. We have to pay for long-term care privately. And that may be the case of trying to get over that 5-year look back line. And even though you understand that for a portion of that 5 years, you're going to be paying privately, you may be doing that. And the other aspect may be a tax aspect to it. While you're paying privately, perhaps you're looking to those assets that have not been taxed yet, like an IRA, because you know that there could be a medical deduction that could offset the taxes that are associated with withdrawing from that IRA. So it's the best resource to use in order to pay for that private pay until you get to the point that you can qualify for Medicaid benefits. So having someone who is sophisticated and is knowledgeable of the state-specific rules can really make a world of difference when it comes to Medicaid planning.
Very interesting. And, I guess taking a step back from some of these, state law and tax law issues, I guess another thing here on the more qualitative side is just gauging the client's preferences for care, right? It's possible that they might have a specific place that they want to go in mind that might be self-pay, and that they might prefer spending down their assets to receive that certain care in that particular location. Would that be another consideration, for the advisor to talk about?
It definitely would. And a lot of it's anecdotal, and some people, it's based on a reality that they've seen. Others, like I said, it's anecdotal. But if you're coming in as a private pay client to the nursing home, there's usually more availability for beds coming in as private pay because they allocate only a certain number of beds for Medicaid paying patients. Now, they are not supposed to discriminate. It's not supposed to affect your level of care, but there are realities associated with that it can be harder if you're going into a facility and you're applying for admission there and you've chosen the one that you want, that they may have less availability if someone is coming in as a Medicaid paying patient versus a private pay patient. And so it's definitely something to understand and understand the priorities of the client to know, is their priority wealth preservation or is their priority to get the best care possible in their later years? Or is there some mix between the two that you can figure out? But those are really important concepts to understand. You're going to get different answers from different people. I think certainly if you talk to the facilities, because they have these laws associated with not discriminating against Medicaid patients, you're not necessarily going to get an answer to suggest that if you go private pay, that you're going to get better care or you're going to have more availability. But there is a reality to it, and it's something to watch out for.
Oh, interesting. And then I guess from the advisor's perspective, is there some sort of thinking about documentation and writing down an individual's wishes, perhaps in advance of it? What sort of tools might they use for that?
Oh, I think it's incredibly important. I think that broadens it to a general estate planning discussion, that when you have a client and they are designating their wishes, regardless of what their age is, they're going to have their legal documents, and a lot of it's going to be dry, a lot of it's going to be boilerplate. But then on the side, if you are documenting their wishes, whether it be with a side letter that they've written themselves or with notes that you are taking to understand what their priorities and goals are, that can be really important. And it can be really important information for their named fiduciary if they are unable to make their own decisions or they're no longer acting in the role of managing their own assets. it can be really important evidence of what their wishes are. And so long as it's not in conflict with the language of their documents, those can be really, really important pieces of evidence for the fiduciary, whether it be the power of attorney or the trustee, to use to understand, okay, this is what this person's wishes were, and here's how I'm going to carry them out. Of course, you can always hard code it a little more, but I'm always of the opinion to be flexible when it comes to those. So understanding someone's wishes, but having flexible documents, I usually advocate for. But the person who is creating the documents, the person who is going to ultimately be receiving care, I think it's really important that you give them the opportunity, not just within the dry legal documents, but within their own words, to be able to express what their actual wishes are, so it gets followed out to the greatest extent possible.
Okay, terrific. Now, switching over to the other case. So let's say the advisor is working with an adult child, and their parent is perhaps on the edge of needing long-term care, or it might be in the near future. What are some best practices for advisors working with a client who comes to them with questions in this situation?
Yeah, I think we talked about it briefly earlier. The first thing is, who is my client here? Is there a power of attorney in place? Is that why the child is asking these questions on behalf of someone else's assets? And so are they in the position where they are already a fiduciary, and do they have a fiduciary responsibility to the assets of the parent and to make sure that they're fulfilling their wishes? I think that's the first thing to really understand, because you need to know, is it asset preservation is the parent's goal, or is asset preservation the child's goal? Because I don't think the child's involvement in itself is problematic. I think that is incredibly common. The issue is whether the child's involvement is going to cause the advisor to accidentally optimize the child's objectives instead of the actual client's objectives, if the client is actually the elder. If the client themselves is a child and they're trying to think through strategies to help the client to, direct, their parent's attorney or their parent's advisor to help them through the process and help them with their wealth preservation goals, I think that is fine. It's just really, really important that the line is drawn and understood. Who is my client here? What is my objective? And what am I trying to accomplish, and for who? Because it could be a really sticky situation if it's determined that in actuality, the parent is the client and the child is pulling the strings on something that the parent might not be prioritizing. That's just what you want to be careful of. So child will typically be involved in these situations. It's completely appropriate. I think it's just important to have that conversation and understand, who is my client, in what capacity are you working with me, and whose priorities are we trying to fulfill here?
So, we've covered a lot of ground today. So from your perspective, what is one key takeaway you think our advisor listeners should have from this conversation?
I think a really key takeaway is that Medicaid planning, it's not simply about preserving the most assets or qualifying for the most benefits. It's really about the client's goals and priorities. This can be a really sticky area of planning because there are moral issues, there are ethical issues, and there are concerns that both the advisor and the client may have as to whether they're taking the right path. So before jumping into planning strategies, it is really, really important to understand who your client is, what their priorities are, what they're hoping to accomplish, and laying out what are the legal methods and the appropriate planning techniques they can take to accomplish those priorities, and then letting them decide whether they want to move forward with those. I think that's what's really important, because we can all, give people planning techniques for anything, for taxes, for long-term care. But at the end of the day, it's about what are the client's priorities? What are we trying to accomplish, and not trying to force any type of thought process on them, force any type of planning priorities on them. Let them come and tell you what are they looking to accomplish, and then just giving them both the options as well as giving them the trade-offs so they can choose the strategy that best reflects what their priorities are.
Well, terrific. I think that is a great way to sum things up. So thanks so much for joining us again today on the Financial Advisor Technician Podcast, Dave.
Thank you so much. I'm always excited to be here.
As a reminder, Kits' Premier members can earn CE credit for taking quizzes on our technical content and also have access to our regular CE eligible webinars, recordings of which can be found in the members section. If you're interested in becoming a Premier member, we'll put a link in the episode description as well. Also, if you're enjoying the Financial Advisor Technician Podcast, please leave us a rating or review on your favorite podcast platform to help others discover the show. So thanks again for listening, and we'll see you next week on the Financial Advisor Technician Podcast.